Let's see whether I get this to work very nicely. I was going to say while my panelists take their seat, but they have. Thank you very much, first of all, to Benno Bühler and Professor Drexl for actually giving me the opportunity to be here today. And really to, I think, to pick up where Jonas left us, to cut through the noise that Schrödinger's cat is making in its box and talk about where the proposal stands. And I think this is a topic that's very dear to me because you could say, you know, we're all very polarized, we're on different sides of the world, and we don't really talk to each other, but we actually should be engaging in dialogue. And for this session, you will see that dialogue really does cover all sides of the aisle, more or less literally, because I have the bench with me, or we have the bench with us, starting with right in the middle of our panel, Judge Hoffmann from the German Supreme Court, the Bundesgerichtshof, and he's joined on his immediate left, your right, by Judge Pichlmaier, who has a double Munich hat. He's the presiding judge of the LG, the District Court, but equally he is qualified at the UPC. The bench is then joined by the parties. On your extreme right, there's Simona Popa from InterDigital, and on your extreme left, there is Steve Faraji from Volkswagen. Steve heads Volkswagen's licensing and litigation, or litigation and licensing, depending on the state of affairs he is facing. Simona heads as the senior director InterDigital's policy and regulatory desk. Now, what would benches and parties be without experts? And that brings us, first of all, to Rudi Bekkers, who's clearly established his expertise at simply getting here by using all modes of transports and navigating a broken-down train, which never, ever happens in Belgium and certainly never happens in Germany. In addition to that, he's also the chair of the standardization desk at the University of Eindhoven. So it's very nice, Rudi, that you're here and you could make it here. And last but not least, and I'm definitely not going to introduce Professor Drexl any more than has already happened, we have the Max-Planck-Institute here. And in fact, I would like to start and hand it to you, Professor Drexl. So we have a proposal. And you could say it's an old proposal. In the world of IoT, something that's more than a year old is Methuselah. You could say it's a proposal that harks back to 2016 or potentially even the smartphone war. So it's aged beyond age. But meanwhile, as we've also heard, we've had a number of developments ranging from industries to, well, new courts, as on our panel. So is there actually still a need? Let's start there. Let's actually take a step back out of the discussion and say, well, in fact, you know, we have pools addressing some of these issues, which seemingly are the source of the regulation. We have a UPC that's been a long time in coming, and now it's here. We have other means of resolving things, whether it's arbitration or the WHO. What's your view on the need before we even go to some of the more detailed aspects?
I certainly think that there is a need for most of its parts. Let me start maybe from a somewhat different angle. Andrea Wexler today also pointed and focused very much on the aspect of innovation and competitiveness of the European Union. How can we bring them together? The question might be, whom does this piece of legislation actually serve? Does it help more the right holders? Does it serve more the implementers? Or maybe the consumers? From a competitiveness perspective, the first two options might be key. Then we look at the firms we have in Europe. How many SEP holders do we have? Fewer and fewer. There are Nokia and Ericsson for sure, but already with 5G, the Chinese companies might be much more important. They are now, Huawei is now number one. With G6, this will even further develop. So should we be concerned about the implementers? Well, also here, this is an international market. Producers may be placed everywhere. And this is where I come to innovation. At the end, what we need is to have consumer benefits, because this is what innovation is all about. We don't need patents that will not be used and will not translate into benefits for consumers. So what we need is indeed implementation, but also we need the technology, and therefore we need balance in the system. And we need what Jonas Hein just said. For that purpose, we need transparency, and this is where the regulation comes into the picture. Just to mention what the regulation doesn't include. It doesn't specify what friend means. A major issue we have on the table of the courts. Shall the courts define what friend actually means? And I think there is a reason why the Commission didn't go that way. The Commission seems to be convinced that it's still the best solution is that the parties actually enter into an agreement and can actually find a balance in the light of their interests. And for this, they also they are the primary stakeholders that need transparency. And here I include both sides, not only the implementers, also the SEP holders need information that the implementers have. It goes in both directions. Of course, we know that the concept of standard essentiality is already quite a tricky one, because standard essentiality means different things at different times. So when SEP holders or patent holders notify that they own standard essential patents to Etsy, for example, there is no control. And we don't really know whether we have a case of over-disclosure. So some patents may appear to be standard essential. They are declared to be standard essential. The court says they acquired the status of standard essentiality, but maybe the truth is a different one. So already at that stage. And this is one aspect on which the regulation touches upon. So we should have essentiality checks. Fine. But does this really suffice? The answer is no. Because especially in a world of IoT, where devices are very diverse, also where the performance levels of maybe computing devices can be diverse, because you can produce maybe a device that communicates over the internet at a slower rate, but you can sell it at a lower price and you still find your market. But maybe this device doesn't need all those, doesn't need the standard essential patents that you need for higher performance rates or better performance. So depending on the device, or the device producer, standard essentiality doesn't means something completely different. And that is typically at a later stage, once we know about the standard, and then the implementer will decide what parts of the standard it will actually implement. So this already shows that there is a major information problem on the part of the implementer. And upfront, don't forget, the patent registries don't provide much information, especially on one particular aspect: who is the patent holder? So who actually can claim a patent when it comes to negotiations? So to have more transparency in this regard is very good, but as you see with the essentiality checks, it's not enough. Do we need more information in this regard from the registry and so on? We probably can't, because here it's very important that the two parties enter into contact, and that also and here I come to the SEP holder, SEP holder. The SEP holder, to have a clue on what the royalty rate should be, it also needs to know about the kind of implementation, how the markets for a particular product develop, and so on. And I point this out again. The products are very diverse, and the SEP or the technology providers do not have the knowledge of all different kinds of markets. So in this regard, negotiations are key, right? They are key. And this also leads to the phenomenon that we will have many, many different royalty rates for different forms of implementation. So we have a large variety in this regard. Just to point on the particular aspect, which is maybe one of the most disputed one, and I guess in the debate we'll discuss this, the friend determination, which according to the proposal should precede court proceedings. However, not to forget, I have to admit that we also had a false understanding that once you initiate the procedure in Alicante before the EU IPO for friend determination, you also can immediately, on the day after, you can go to court and sue. So that's very important, I think, and solves many of the issues. Also, the question of lease pendants, to have a court proceedings here in Europe, that might also be quite important. The question here is, does this make sense? To me, and I think here I also speak for the other drafters of our proposal, yes, it does. Yes, it does. And I think even more so in the light what we see now occurring before the courts, because there are two stories about the role of the courts. The one story is the courts have to distinguish between whether we have a case of hold up or hold out. I don't know how often I have read this in the literature. And then you may not even see that there is something in between. That maybe both parties play along the rules and with good faith, right? That's the third possibility. And what we want to achieve, that's the other story, is that parties can agree without the whole help of the courts. And this is what the friend determination proposal actually includes. And to do it before you go to court may also alleviate the burden on the courts, whatever the court might be. So in this regard, and also it may lead to much earlier implementation. If this works, there is of course always the institutional question: can we actually deal with those issues institutionally? It depends on human beings. Will we have the experts? How do we actually attract them? And how will the procedures work? So this is to be seen. Maybe just to say another word on the future perspective. We have already talked about what will come next. And the question is, of course, what will be the standard we are talking, all these standards we are talking about. And if we remain for a second with the mobile telecommunications standards, the regulation will apply to future standards, and this will be 6G primarily. And then I in the literature, I saw that we may have more than 100,000 standard essential patents. And with the registration system, oh my goodness, that's a lot of work for the EU IPO. So these concerns also exist. But is this an argument against having the registry? One may argue, yeah, it's a challenge for making it operable. But we even need more transparency. The more standard essential patents we have, the more urgent it is to have transparency. So that's almost a curse that we now see with the rapid development of those technologies, that we are getting at the fringes of administrability of such systems, which we should also keep an eye upon. Thank you for the moment.
Thank you, Professor Drexl. So I think there are two things which you typically hear about the proposal. It's very complex, is the first of it. Listening to Professor Drexl, it's actually not that complex. So thank you for, I think, putting it to us in a language that makes it very clear what are the borderlines of this proposal. However, the second question is well, will it work? And that's maybe a good segue to listen to Simona and to Steve from, well, the boiler room, so to speak, of implementation or of a potential implementation. What are your thoughts on the regulation and what it could transform us to? Simona, if you could take us away first, please.
Yes, thank you. I'm not sure where to press. This one. Yes. Thank you very much. So I really liked Jonas' story with the cat that is dead and is alive at the same time. And I have to say, I think it describes the proposal very well. And looking through my notes, I think it describes a lot of things that I'm going to say. Everything is either dead or alive, or both at the same time. So I'm going to start with some facts. I'm going to take a few steps back. Thank you to Professor Drexl for this overview of the regulation, of the draft regulation. And I think it's very obvious we stand on a different side because we're the receiving end of all the obligations and new commitments that we have to undertake under the draft regulation as it stands right now. So I really love the question for the panel, is it still fit for purpose? So for that purpose, I'm going to, again, take a step back, look at some economic facts, and then I'll make three main points about the evolution of the political environment, the evolution of case law very briefly, because I know we have a panel afterwards on this, and a couple of substantive points on the regulation to sort of counterbalance a little bit some of the points that were made earlier. So in 2024, according to IMF data, the GDP per capita in the US was double than that in the EU, $89,000 versus around $45,000. According to the European Commission, 2/3 of this gap is due to an innovation gap, among other things caused by lower private investments in the R&I sector. The second fact, in 2023, the European Investment Bank did an investment survey. And in this survey, 2 out of 3 companies pointed out that the regulatory burden in Europe is one obstacle, a major obstacle for companies to make long-term investments here. So a heavy administrative burden makes Europe a less attractive place to invest. The new political guidelines of the European Commission after the elections last year seem to address, in theory, these facts. We have focused on economic growth, economic security, global competitiveness, and 2 of my favorite quotes are from the political guidelines: we need to put research and innovation at the heart of our economy. And in the mission letter to Commissioner Séjourné, it is said, you will ensure our intellectual property policy continues to reward innovation and creativity. So here we have the dilemma of the cat that is dead and alive. Another sort of focus for the new commission is the legislative simplification. And for the very first time, we have a commissioner that is in charge of this agenda of simplification. And looking at the SEP regulation through the lens of this new agenda, focusing on research and innovation and promoting investments through intellectual property as well, the regulation does not seem fit for purpose. So that was one long answer to a very short question. We also need to see that the objective of the Commission to drive European leadership in tech and standardization stays alive, so half of the cat. The second point on the UK's law. I will not go into a lot of detail, also because that's not my specialty area, and we will have a discussion later on. But there seem to be some recent cases from the UPC seem to show more focus on the license offer by the patentee and an actual front assessment. And this is an approach which looks less at the behavior of the implementer, as German courts have been doing, and we know that this is one of the major criticisms that has been attributed to the German courts. So we see now that there are evolutions in jurisprudence that start addressing things that the SEP regulation aims to correct. So again, is the regulation necessary or fit for purpose? And I would say no. Lastly, a couple of substantive points about the regulation. The asymmetry of commitments in the regulation. There is, on the one hand, as we all know, the obligation, the front commitment of the SEP owners, but on the other side, from the implementers, we don't have any commitment to enter into a negotiation or to take a license. and the regulation doesn't address this asymmetry of commitment in any way. And my last point would be about the SME. We all keep talking about SMEs and small companies, and the new political guidelines of the Commission also require an SME and competitiveness check. The short answer, in my view, if we were to run an assessment of the draft regulation through this SME and competitiveness check, I don't think it would stand the test. The Commission also intends to support and encourage SMEs to engage more in global standards setting process, but the regulation does not support this objective either. So I'll draw here a temporary conclusion. I would say that, in my view, the European Commission should rethink the structure of the of the draft regulation, focus on SMEs, apply maybe some of these mechanisms only to SMEs, offer SMEs more practical support where they lack that support in assessing their need for information and so on. And I think this would indeed support SMEs, participating in the standardization process. We seem to be talking a lot about theoretical issues. The IoT market is not a fully developed market yet, and yet we see only problems. We don't see the solutions that are underway, and David was talking earlier about some of these programs, licensing programs. I think there's a lot happening in the market that actually doesn't justify such a heavy regulatory intervention for now. Thank you.
Thank you very much, Simona. Now, Steve, you don't really qualify as an SME representative, but you certainly do qualify as an innovator, maybe a little downstream from the SEP holders direct. What's your take? Take a step back, think some more, and really give more practical guidance, stick to the regulation. What's your take?
First of all, thank you for I have to speak. Thank you. First of all, thank you for the invitation, and I'm honored to sit on such a prestigious panel. Well, it comes as no surprise that we at Volkswagen fully support and welcome the SEP regulation. It provides guidelines for SEP licensing, which are really, really necessary in our opinion. I would argue that the system as it currently stands is not working efficiently and friendly. It has high transaction costs in litigation. It has a lot of problems, and they are not resolved. And by the way, just a remark, this is even without regulation, we have these problems. So I really hope that, and I'm really looking forward to have the regulation in place. We believe it will help a lot. And a little bit, I generally agree with Simona, but one point I may have to disagree is that we should proactively tackle problems we see in the future. And I think really all stakeholders, patent holders and implementers should be interested in having a solution for the IoT industry and future topics. We have a lot of multiplication of implementers, a lot of new standards and new technologies which are falling under the SEP regulation. So we should really not say there is not a problem yet, but see how can we tackle possible problems that we see on the horizon. And perhaps one point that is often brought up, David also said it, and I'm generally, I can concur, but I really doubt that because I doubt the effect and result to say that the most of the licensing is resolved amicably, most of the problems, and there is not much litigation. No litigation, as Joachim Henkel before said, does not mean that there are not substantial problems. The situation leads, I would argue, to a lot of implementers to be forced into a license, or at least taking a license which is not friend in their assessment. And really to look at the future and more development in IoT, it's really necessary to become more efficient and transparent in the SEP licensing regime. The framework is at the moment not fit for this purpose, and we believe that the SEP regulation will help massively in this regard, and it again will benefit all of us. One point, but I'm afraid to bring this up sitting in front of Judge Sigan and Judge Pichlmaier as a co-panelist, is the recent UPC decisions. Last year, we had some hope that the UPC will probably take a new look and a fresh look at the interpretation of the CGU Huawei ZTE decision on the point of the willingness that the German courts have used, and the interpretation the interpretation used there. We see at the moment, at least in the first instance, not a really major shift from that interpretation of the willingness, which we find disappointing, to be honest. I believe this is really a point that leads to major problems. It's not a major issue for the SEP licensing regime and ecosystem overall, but it leads to a problem for European-based companies, which are then looking at licensing negotiations with another perspective, with a threat of injunction and a possible injunction out of Germany or the UPC courts. So I would encourage that we perhaps take really a fresh look at these court decisions and perhaps at the interpretation. But who am I to tell judges what to do? But I'm just raising this point out of personal interest. And I really urge everyone, I know this is oftentimes a huge discussion because everyone disputes this, but we are still coming from an umbrella of antitrust and competition law. We are doing standardization cooperatively, everyone together, to bring innovation forward, to bring benefit to society. And the outcome of it should be a fair return on investment, but that return on investment should be at some point limited to really fair and reasonable measures and not being excessive. So having this antitrust thinking and the wisdom in mind, I urge everyone to perhaps reach out a hand and to try to resolve these issues and perhaps support the SEP regulation if you are willing to do so, Simona. Thank you.
Well, as an antitrust lawyer, what can I say? But I do think, Steve, there is a general message that's a nice segue to our next topic, if I may, because you mentioned, in the end, for SEP licensing to work from both sides, it's really a cooperative process. But we also, in our very first panel, had, I think, both Carl and David mentioned this, dare I say, issue of trust. On both sides of the table, the difficulty to, go to the management and say we're actually getting the right price, maybe even a fair price. And I think maybe, Rudi, on transparency, which in many ways is the key of the proposal and goes through the 4 pillars of it, what are your thoughts? Are the measures that are being contemplated optimizing transparency? Is this a good thing? It's your study, so we're looking forward to your insights.
Oh, thank you. And thank you for having me here. I'll get to your question, but I want to do a bit of introduction. And you already had a number of academic references this morning. I will not disappoint you as a scientist myself. I took a paper to read this morning on the train, my rather dramatic train trip. And it's a paper that's actually already pretty old, and it's called The Market for Lemons, Uncertainty and Market Mechanism. And this is a paper about selling and buying second-hand cars, something that many of you have been into, maybe when you were still a student, maybe you don't have to do that anymore. There's a big uncertainty when you buy a second-hand car. What is the condition of that particular car? And probably true that the seller of the car knows much more about that car that you're buying than you as a buyer, and might have a giant advantage and can abuse that disadvantage. And interestingly, this paper concludes that in the end, it is also very much in the advantage of the car seller to increase transparency, because in the end, it will terribly hurt the market if they take disadvantage of their position. This might all sound trivial. It wasn't when it was written. It still isn't trivial now. Actually, the person that wrote this is George Akerlof, and he got the Nobel Prize for Economics for this particular paper alone, or at least his work on transparency. And here I want to get into transparency because that's the link, of course, to what we are talking about today, transparency and how that comes into standard essential patents. And I'm going to very much focus only on the essentiality test part of it. That's one part of it I'm looking at when I was the principal investigator of a group of people that did a feasibility study for the European Commission, trying to ask the question, is it possible? Can you do it with sufficient quality? what are the type of procedures you'll be using, a lot of the technical, bolts and whatever of the proposal. So I'll be taking that view in the next observations I would like to make there. What type of transparency do we want? It's called essentiality directive. So one of the things that we see the Commission writing about, is a patent essential or not for a given technological standard? We already had Professor Drexl talk about who is the owner or claims to be the owner at that moment for that particular standard. In reality, there are much more questions, and they were already touched a bit upon. I'm happy for that. But it's also like the question, and how does that play out for a particular device or device category? This is getting more and more complex over time. It's not that we only have one type of mobile phone and it's either applicable for that or not. There's a very diverse world, something that the actual essentiality regulation doesn't get that much into yet. How about optional parts of a standard or mandatory parts of a standard? How about shares of essentiality? So essentiality is not one single term, it's a whole set basically of data points that we would like to get more insight in the hope that we get a market better working. Now, I'm going to make a couple of observations and then I want to get to a couple of more what I still consider to be open questions on the directive. First of all, is this possible? Is this doable? The first thing I would say, this is already being done on a large scale for a long time. Patent pools have been doing this for very long, for good reasons, because they wanted to make sure that they were not acting any anti-competitive or antitrust matter. But they've developed this, they have experience now for decades doing this particular thing. But not only patent pools, a lot of companies at a degree of sophistication look at their own portfolios when they set up their licensing program, look at the portfolio of other companies, especially when it turns into a dispute, they're going to look deeper into that, might get into a court case. A lot of essentiality checks have been carried out in court cases. It is happening all the time. There's an enormous amount of duplicates efforts going on, but in most cases this data is never shared, never gets transparent, perhaps with the exceptions of pools. And there's such a waste of actually people doing the same thing over and over again and basically keeping the result out of the public part. Now, I want to turn to another question that's been asked to me several times, and then, the manpower, or I shouldn't say manpower, people power here. Do we actually have the capacity if we want to set up as a public system as the Commission has the ambition? Is it possible to do so? And when we were doing the study, we already kind of identified possible individuals that could do the task of assessment or evaluating or checking, whatever you want to call it. I don't care about the terminology here. Patent examiners, for example. And I should mention maybe that when we carried out the study, it was together with the European Patent Office and 6 other national patent offices, and with a couple of SEP owners, some really big SEP owners, as well as some smaller SEP owners. So we had a lot of people that chimed in during the study looking at these things. And actually, the study would never have been possible that we did without the European Patent Office and the national offices and these patent owners actually to gain us these type of insights. So do we have the people? It could also be third parties, I should say, but other type of examiners. Well, I think it's obvious that the patent examiners do certainly have the profile to do so. One other group basically is patent attorneys. That's a large group in Europe. We made an inventory of that. In Europe, we have over 10,000 patent attorneys that are officially registered with the European Patent Office. Actually, that's all, because you need to be registered. Of course, they don't work all exactly in the technical area of technical standards, and about 40% works basically for a company and 60% is kind of independent. But still, if we take all of that, we still have more than 500-600 patent attorneys that would typically be qualified. These are exactly the group of people that the patent pools use basically. The patent pools don't do the assessment themselves. They basically rely again on experts. They hire people that can do it, like patent attorneys, exactly in the same way, I think, as the regulation is intending to. So my concern is certainly not as much like, is the person power available? There is the talent and the qualified people in Europe. And also, basically, other parties could do it. Then we have to look into impartiality, of course, a bit more. That's already guaranteed for examiners and attorneys, but certainly not impossible to have others. Another thing, and I'm just picking out some parts of the study that I feel strong about, is that any good system, I think, and in this case we're talking about something important like essentiality, should have correction mechanisms in them. that party can basically challenge the outcome of a conclusion if they think it is wrong. And this is very essential for not only having good quality data, but also having trust in the system. From any perspective, that people have the belief, the possibility basically to challenge when they believe outcomes are wrong. And I do see in the proposal at least 3 phases for this. You can submit observations, I think it's Article 30 of the proposal. There's a peer evaluation that you can request, another article, Article 32. You can also bring it to the EU IPO Board of Appeals. Bit of similarities as we know it in the patent system, Article 29. So I'm happy to see that in this proposal we have at least this part very well built in. And then getting to this question of improving quality and gaining confidence and also maybe efficiency and create incentive. For me, it's very important that we, as much as possible, use the knowledge already out there in the market. So do invite, for example, patent owners to bring in their own beliefs, their claim charts about what makes that particular patent essential in their view. Don't reinvent the wheel. Don't give this assessor like 10,000 pages of 3GPP specification and 50 patent claims or whatever. The most efficient system is where you allow a patent owner to argue, this is the reason why I believe. Exactly like it works in patent pools. We don't have to reinvent the world here. It is built into the system right now. Patent owners can share their invitation. There's a little bit of unclearness, I think, in the language right now, if they always do so or they should be invited to do so. We could look carefully at the text, what the proposal exactly say there. I would go one step further, and I think also in terms of incentives, it would be very important to engage these parties, to provide incentives that they do share their own view about maybe in fee reduction, but maybe I'm making some people angry if I say something like that. But I think certainly the proposal could also benefit from incentive on the side of the patent owner to share their own beliefs about that. Let me go to a couple of open questions, and then we'll finish that. Things that I find interesting in the proposal, and I'm generally positive about the proposal. There's a lot of elements that I like, so don't get the impression if I pick out these open points here that I have major issues with it. But I think they're points worth raising and together thinking about. And one of them is that in the end, I think everybody understands that they don't propose to assess every single patent family on the world at the same time. There's going to be some selection there, selection standards, and there's going to be sampling there. And the sampling part is going to be critical to convince people it is basically it is generalizable, it's a reliable piece of information to look at parties. I think there's a study issued by the European Commission, or at least a call for studies that will very much look into all these implementation aspects. Very important, I think, to do that right. There's also the possibility of patent owners, I understand, to propose up to 100 of their own SEPs in the process. And that's very interesting how that relates to the sampling process, and if we still have generalizable data, and there's a little bit of text of that in the proposal, but I think it's worth to dig much more into it. I'm not going to do it right now. Also, other third parties can propose up to 100 SEPs per standard, I believe, to do that. But of course, many parties are SEP owner and implementer at the same time. Are they allowed to bring in 200 of their own SEPs, one as a third party? And so there are many things to look at. Which patterns do we exactly look at? And does that still create an honest picture of the whole part? What is made transparent? I already talked about a little bit, the fact whether something is essential or not. But essentiality is a complex thing here. Essential against what part of the standard exactly, at what point in time. Many of these mobile phone specifications, these standards are constantly evolving and adopted even multiple times in a year or so. So you really need to know exactly for what version, otherwise it's misinformation. You need to know, is it about optional parts of the standard, is it mandatory, and how does it map to actual product? Does it map to a phone, does it map to an IoT module, or a SIM card? We only have a very small subset of all these parts of the standard, but nevertheless there might be essential things for a SIM card. And I think I'm going to leave it at this point. But I think generally there's a lot of elements that I'm happy to see back from when we've been looking at this and studying this essentiality proposal. And in that sense, and limiting myself now to the essentiality testing part, what we have studied and considered about the feasibility, I think I see many of these elements back into the current proposal for regulation as it is now. And I'm happy to see it in this form, even though I think there's still room for improvement here and there, clarification and discussion on these items. And I'll I'm going to leave it at that. Thank you.
Thank you, Professor Bekkers. Professor Drexl, fit for purpose. A very quick reaction, and I'd also like to invite the other panelists to pitch in there.
If I may react directly, again on the essentiality checks.
Microphone.
Sorry. Yeah, now you hear me better. May I ask you a question? What's wrong about over-disclosure? Who is harmed by over-disclosure? Think about it. Maybe it's not the implementer. Because if you apply a top-down approach to calculating the royalty rates, then it doesn't matter. Then it doesn't matter. The true problem is, and you hinted at it, it appears in a pool. It's misallocating income among SEP holders. Those who over-disclose more than others may benefit unjustifiably against the policy of the patent law, right? And also the standardization, of course. So this has an adverse effect on innovation, right? So we have a public interest in it, but it's, I think that is very important to highlight, because whenever we talk about SEPs, we only think in terms of conflict of interest between the technology providers and the implementers, right? So in this regard, that's a particular benefit that we should not forget, right? Yep. So just that's also fit for purpose, I would say.
Thank you very much. I think, Simona, this actually brought us back to the effect on innovation.
Yep.
So what's your take on transparency and disclosure?
So just a few points just to react to some of the things that were said about essentiality checks. We haven't spoken much about the cost of essentiality checks. And I think if somebody runs some calculations, which I'm not going to do now, it turns out that patent owners, SEP owners, are the ones that are going to carry this burden exclusively. So I think that's a completely disproportionate approach to let's say, the objective of ensuring transparency. Another point that I would like to raise, we were talking about legislating to anticipate problems. As far as I know, I've been doing this job for about 20 years, and we have the better regulation principles that the Commission is bound to. So if we anticipate problems, looking in the future, it means that we don't have an evidence. We don't have actual facts to have seen on the market that something happened or something didn't happen. So I have a slight problem with that idea that we legislate for something in the future where we don't know that we have problems yet. And for that purpose, I think the scope of the regulation should be, the burden of proof should be turned the other way around. We should include in the scope only standards where there has been actual evidence that the market has failed. And another last point, I do appreciate the enormous amount of work that was done during the SEP expert group. A lot of materials came out of there, and the study was very, very detailed. But one thing that struck me, though, was that there was no consensus at the end. The experts, everybody in that room, highly valued experts in our industry, but there's no actual consensus. So the experts themselves, they couldn't agree on the majority of the tasks that they were discussing. So there were a lot of conclusions, but to my recollection, there was no uniform conclusion from that. So I would like us to remember that. Thank you.
Judge Hoffmann.
Well, may I just jump into the question whether it's not more efficient to have the essentiality check just once and for all, rather than one essentiality check done by the SEP holder, maybe 5 or 10 essentiality checks done by big implementers, and no essentiality checks done by the small companies that cannot afford it and have no idea of what they have to pay.
Not an answer to this question, but a more general concern, which I think we should be discussed in this scope. From my personal perspective as a judge, I can see that we are not alone at the world. Europe is not alone. we have litigations for the same patents and for the same SEPs all over the world, in the US, in China, in Brazil, wherever. And with this regulation, I think maybe we will pull out Europe as an important place for these litigations and stipulations, because maybe we are talking about worldwide licenses. What we see at the courts are litigations about worldwide licenses, and we can see it in the UK courts, what happens there. And my concern is that with this regulation, which is the only regulation of this kind all over the world, Europe will not be attractive in the future as a place for these litigations.
Steve.
Yeah, that's bad news for law firms, but good news for implementers and companies who are a little bit fed up with all the litigation. I mean, the question is, Judge Pichlmaier, whether or not the reduction of litigation leads to quicker and efficient licensing. You know, if that helps with the SEP regulation, I think that would be a good thing. But I'm with you. There is a risk that perhaps internationally that Europe might get behind. But I think it generally would be a good thing, because litigation is not really something we should strive for.
Well, conscious of time, there is bad news in the sense that the Chinese seem to be adopting a copycat of our regulation and do so very quickly. So we'll see what that implies geopolitically. As to the point of getting quicker licenses, as the segue to at least the last topic that we should try to get our arms around in this panel, if we move, and this is really where we need the bench at some point, and I'd like to hand it to you two in a minute, to a dispute. Then we kind of move away from, you know, the lofty, is it good for innovation? Do we need it? Is there enough transparency? We then move to the dollar value, or for all I care, the euro value. Is or is not, you know, an offer on the table friend? Now, clearly with an eye on avoiding, you know, we heard a lot about costly litigation, some of that litigation, or at least getting parties to continue to talk. There is the friend conciliation that's been brought into the proposal. And the idea would be to have some sort of a safe harbor, if you want, to negotiate for 9 months without the threat of an immediate injunction. And maybe, Judge Hoffmann, we start with you, and then if we could move to Judge Pichlmaier. What's your view? Do we need that safe harbor? Is this safe harbor, as it's been created or being created now, the right answer to the right question? What's your take?
Well, thank you very much for giving me this opportunity, but I come right back to the question. I just want to make a side remark. Being the first judge to talk here, judges in courts, even if they are in Germany, do not lay out traps. And it's always good to think that judges have only one intention, is to apply the law. You might criticize us, write an article about it with good arguments, but we have no other intentions. Okay, but now come back to the question, what's about friend conciliation? Well, the problem is, as the panel before has already laid out, we are not in a real market, we are in a locked-in market. Nobody has the option to say no. And this is, of course, difficult for negotiations. Negotiations are much easier if everybody can say, well, I'll leave it up and say, no, we don't have to agree. But that's not possible with SEP. Everybody knows, everybody in this room should know this. And if negotiations don't go well, like everybody, like in other situations, it's good to have an independent third person in the negotiations. That's why many people say arbitration are good, because you have a third person, independent, steering the talks. But arbitration, in a normal way, require consensus. And nobody is obliged to give consensus, like although he or she is obliged to render a friend a license on friend terms, to give or take such a license. And that's why somebody says, well, we should have a mandatory arbitration. But the problem of mandatory arbitration is that it would violate the right to go to court. And on the other hand, in some conferences, I heard somebody say from the US, I remember, even if you have arbitration, it would be good to have the possibility to appeal. Many people don't like it that one arbitrator or one panel of arbitrator make a final decision and that's it. Even if you go to court, you like to have the possibility to appeal. And that's probably a good system that you have the possibility to appeal. And now, if you take a look at the friend determination or the friend conciliation as it's laid out in the SEP regulation, this fulfills all these needs. No consensus is needed. Either side can decide themselves to initiate a friend determination, and the outcome would not be binding. You have the possibility to appeal against it in the way that you go to court and litigate about the question. And of course, if you do a conciliation for 9 months, the conciliator panel, of course, has the possibility to lead the parties to a settlement like an arbitrator does. And that's why you have all these advantages that you don't have right now because you need a consensus for arbitration. But even without a settlement, the proposal would not be, the proposal by the conciliator panel would not be effectless. If you take a look at the judgment of Huawei versus CTE in the paragraph 67, you see that there is an obligation to provide a security, like a bank guarantee. From the point of not agreeing to the offer of the opposite side, the implementer has to render such a security which covers the use from the very first beginning, the use of the patent. And we know that this obligation does not have a big effect right now because on which calculation basis shall such a security be provided. Now, the friend determination renders a proposal, it renders a number from which you can calculate such a security to be provided. And from this point on, I think if you provide such a security with the obligation to pay interest for the use of a license, from this point on, I think it doesn't make sense to hold out anymore. Because you have to pay for the bank guarantee, and the bank has to guarantee all the damages that you cause by using an SEP without a license. And even better it would be if you take a look at the interim licenses that are kind of established by the UK, recent UK judgments. If you would have an interim license agreement by the parties that say we provide preliminary license rates, and I would prefer a system where you pay 80% of the license rate and 40% of a security to be provided, then the friend determination would be a very good basis to let such an interim license work. And of course, if the parties have to pay and if the parties have to provide a security, that's for both sides a situation which they do not want to continue because only the bank has a benefit from it. And that's the best way to prevent holdout and hold up as well. And the friend determination procedure is a way to give a number what might be a good estimate for a preliminary license rate. And these are, in my view, very good reasons to ask for a friend determination very early. if you see that the other partner that you're discussing with is not negotiating constructively, then you have the right to immediately ask the EU IPO to start a FRAND determination and get to a proposal and get to a third party that helps solving the issue. And if all of this does not help to settle, which I think should be the case in very rare cases, even rarer, more rare than of today, than today. The proposal of the conciliator panel has to come with reasoning. It's not just the number, it gets a lot of words that say why it's this number and not that number. And this serves like an expert opinion in front of a litigation that has to be done if the parties do not settle. So the court benefits from this expert opinion because it focuses and it structures the litigation. You don't have to start from scratch. You just can pick up the points in the expert opinion done by the conciliator panel in their proposal and say, well, this point is not correct and this point is not correct, and maybe we should take a second look on that. And by this, if a litigation has to be done, it can be done much faster than the court would have to do if they would have to start from scratch.
Thank you very much. Now, Judge Pichlmaier, imagine it comes to you.
Yeah, as I said, my personal opinion is that a lot of this regulations in the SEP regulation is kind of over-regulation. But what is really, from my point of view, a good idea is everything combined with this conciliation. And that's also my experience as a judge. To make it practical, we, for example, had in some years ago this connected car cases. I don't know if also Volkswagen was involved, but for example, Daimler was. And they came with a lot of suits to the courts, and we talked about infringement, we talked about validity, but we didn't talk about what was the main issue in these cases, and it was licenses. And therefore, I think we should stick to what is really important in these cases. And conciliation is a very good idea for this to really go to the main issue. What is it all about for the parties? What is the main topic? And in these SEP cases, the main topic is licenses, and not if this single patent in the case is valid or infringed, because in the standard there are thousands of patents, and everyone in the courtroom knows that at least one of these patents will be valid and infringed. So that's not for the parties who come to the court. And in the scope the court and the legal system has, for example, in Germany, they then discuss about validity and infringement, but that's, as I said, not the main topic. And therefore, I think this conciliation idea is really a good idea. Maybe you can keep it a little bit shorter than it is proposed in the SEP regulation. My experience, we also have this idea of make mediations for the parties in such litigations, not only in these FRAND cases. And my experience is that you can do, if the parties are willing to have such mediation or conciliation, you can do it very quick and see if it will work, and then you can finish if you see it will not work and the parties need a judgment. But to implement such conciliation as part of the proceedings is really a good idea, I think. Maybe not as it is proposed in the details, but as generally spoken as an idea that's really as a safe harbor. I think that's something which is good in this SEP regulation proposal.
Thank you very much. So we have learned two things, I believe. The first is that, well, judges don't trap us, but conference organizers do. And so we are actually over time. While this panel could go on for the next 2 to 3 hours, there's also coffee. So as balancing and trade-offs go, I think we are at the point where, unfortunately, I have to close this panel. The other thing we did learn is that dialogue, as indeed the actual exchange of ideas, is very important when confronted with, new regulation and new proposals. And I would like you to join me in thanking my panelists for engaging in dialogue. Thank you, folks.